This show is produced by the Hartman Media Company. For more information and links to all our great podcasts, visit hartmanmedia.com.
Hey, good morning, Jason Hartman and team. Thank you for all the great content, all the great guest speakers you have on. And Gina and I feel fantastic about doing what we're doing. And we'll just keep on listening and take care, and wish we could see you all soon, and hope that'll be happening. Take care.
Welcome to the Creating Wealth Show with Jason Hartman. You're about to learn a new slant on investing, some exciting techniques, and fresh new approaches to the world's most historically proven asset class that will enable you to create more wealth and freedom than you ever thought possible. Jason is a genuine self-made multimillionaire who's actually been there and done it. He's a successful investor, lender, developer, and entrepreneur who's owned properties in 11 states, had hundreds of tenants, and been involved in thousands of real estate transactions. This program will help you follow in Jason's footsteps on the road to your financial independence day. You really can do it. And now, here's your host, Jason Hartman, with the complete solution for real estate investors.
Welcome to episode 2155. Today we're going to talk about asset protection and entity structuring and estate planning. This is going to be a good show for you. I'm sure you'll enjoy it. And remember to go to jasonhartman.com/protect if you want to get started on this and do it very inexpensively with a real attorney. A real attorney, not these mills that spit out documents. This is real attorney consultation, real attorney help, multiple attorneys in the firm, and you can sign up and do this very inexpensively, starting at $29.97 for 3 entities, and you can do more as the need arises. jasonhartman.com/protect. Let's get to our guest today and take a deep dive into some of these important issues. Remember, this is the one thing that is really quite easy to do, but you must do it in advance. You've got to dig your well before you're thirsty. And that's what we're going to talk about today.
It is my pleasure to welcome a returning guest back to the show, and that is my good friend Mauricio Rauld, and he is founder of Premier Law Group. He is a syndication attorney, and he is deep into the world of real estate. He's all about real estate, and he thought of an interesting topic that I think you'll really like, which is I'll throw out some various asset protection vehicles, and Mauricio is going to poke some holes in them. You know, you hear a lot of these people out there with their hype and sensationalism about be bulletproof asset protection. This is the strategy you need. Folks, nothing is bulletproof. Everything has weaknesses. You know, you've all heard the old saying, a chain is only as strong as its weakest link. And that is definitely true. But I will tell you that if you are not thinking about these topics and you are not setting up entities and strategies for yourself, you are making a huge mistake. This is the one thing in life that is really inexpensive to do. It's quite easy to do, but you must do it in advance. You must do it in advance. That is the one area that you cannot fail. You can't be late to the party on this. It's got to be in advance. So Mauricio's nodding his head a lot. So without further ado, welcome. How you doing?
Thanks, buddy. Good to see you again. Always great to be on the podcast.
Likewise. So LLCs, maybe we'll just start there.
Let's do it.
Of course, there are 50 states. According to Obama, there are 57 states. We won't debate that right now, but
are there more states or more genders? What's going on?
No, I think there's like 64 of those actually. So, you know, look, you can't just talk about an LLC generically, right? Because of course, every jurisdiction has different laws. And if you're using the LLC from one state and domesticating it or registering it or whatever the right terminology is in another state, then the rules may change.
Yeah.
Okay, so there are complexities to all of this stuff. So talk to us about LLCs. Are they bulletproof?
No, they're definitely not bulletproof, but they're definitely better than nothing, right? So this is all about having layers of protection, right? And so I talk a lot about that in the book. But first of all, just think of LLCs as a backstop. Like your first line of defense is got to be insurance. Like as much as I hate the insurance world and I've got my pet peeves and they've got a ton of issues, so I definitely want to talk about the holes in insurance policies. But in the event insurance doesn't cover you for whatever reason, or you're underinsured or whatever, you want to make sure you have a backstop to protect you for the next level. And that's where LLCs, limited liability companies, come into place. The beauty of LLCs is that they will limit your liability, meaning whatever happens if you own a property, for example, in a limited liability company, and somebody slips and falls on your property, or maybe a boiler explodes, some injury happens, the owner should be responsible, which is the LLC, and that should generally limit your exposure to just what's inside of that LLC. The challenge, I think, where people are where the thing starts to fall apart a little bit is you do have all these promoters that, say, hey, look, you should set this up in Nevada or Wyoming or all these great states. And those are premium asset protection states. Just so we get it out of the way, I consider Wyoming, Nevada, Delaware, and now Texas, by the way, as of September of last year, Texas has joined the ranks of sort of premium asset protection states.
There are many that are good and bad for different reasons. But, one that people don't commonly think of that I hear is pretty good is Alaska.
Yeah, but Alaska's great for trusts, and that's sort of a more advanced strategy. Like if you get an asset protection trust, I believe Alaska was one of the first, if not the first state to come up with a trust, but I think other states are better just because they have shorter statute of limitations, which is beneficial. But the reason that, let me just backtrack a bit. The type of LLC will dictate where you set up these entities. So if you have a property in Dallas, Texas, for example, right? And you create an LLC in some other state, like in Nevada, and then you have to then register the company back into Texas. It really doesn't matter, because if somebody slips and falls on your property in Texas, Texas law is going to apply. There's nothing you can do about it. If you live in California, which I know you used to do, and you used to love living in California, down here in San Diego, I remember.
Don't put words in my mouth. I didn't love California.
You told me it was the greatest state that you've ever lived in.
Kidding me? I didn't say that.
Just kidding. If something happens in a state, you get into a car accident in California, you have a slip and fall on your property in California, I don't care where you set up that entity, California law is going to apply. And so there's really no benefit of setting these things up anywhere else. However, when it comes to actually owning other assets, meaning what we call holding companies, right? They don't really do anything. They just own other LLCs that in turn own other assets. Because they're not doing business, they're just literally sitting there holding membership interests in another LLC. That's where setting these up in other states like the Nevadas and the Wyomings and the Delawares of the world starts to make sense, because they have something called charging order protection, meaning if something were to happen to you, Jason, unrelated to your assets, got nothing to do with your properties or your businesses, you got into a car accident or you got into a business dispute or something happened, there's a judgment against you. Now I want to know what you own. It is beneficial to say, hey, I don't own any of this stuff. I just own a Wyoming LLC or a couple of Wyoming LLCs, because I'll have access to what's called the charging order protection, which is really, when it comes to LLCs, is the number one protection, which is going to limit me, who has sued you, is going to limit me to your distributions of whatever distributions you were getting. Those will come to me now because you have a judgment, but I can't get ownership of your LLC. I can't get control of your LLCs. And so that's really where the benefit of LLCs comes into, is this charging order.
Let me help make some distinctions here. Okay. One of the huge mistakes that people make in trying to understand and navigate the world of setting up estate planning and entities to protect assets and so forth is they fail to understand the difference between the internal threat and the external threat. They seem to only think about the internal threat. Correct. That example is a cliche. Oh, you have a property, it's owned in an LLC, the tenant slips and falls on a banana peel and they sue you. That's just so rare. It's easy to insure around. That's not the problem. But what could happen that can be more devastating is an outside thing occurs. It's an external threat that occurs from some other part of your life. And then they look for your assets and they think, oh, you own this property, right? There's equity in it. We're going to try and take the property. And so what happens here, folks, is that in states like the Socialist Republic of California, that are not good states to do business in, and many others, they can foreclose on the assets of the LLC. And most of this, when I say LLC, probably, but you correct me here if I'm wrong, probably is almost synonymous with corporation. So if it's a corporation, or at least a closely held corporation, it's mostly going to be the same scenario, probably, right?
Let's talk about that, because there's an important distinction. But where you're going is exactly right. So finish up your point, because you're doing a great job of explaining
it. And I'm not a lawyer. Okay, I gotta say that, and I'm not a tax advisor. But you don't want them to foreclose on the assets of the entity. Okay, what you want, I mean, you don't want any of this. Okay, but if you're going through it, you want them to have the sole remedy of obtaining a charging order from the court. And that charging order is basically kind of like this. They say, okay, look, Mauricio owns this LLC in Wyoming or Nevada or Delaware, or now Texas, you say is also very good. Mm-hmm. We're going to go knock at the door of that LLC and ask it for money. And as long as no money leaves the door of that LLC, they can't get it. They have to just wait by the door indefinitely to collect. So in other words, if you don't take a distribution, they can't do anything except sit there and wait, right?
That's a beautiful analogy. It's one of the best ways I've heard explain it. Like literally there's because I talk about the distributions and the liens, but that's really a good analogy. Like you literally, if there's money flowing out of your LLC through this door, then that's going to go to the creditor because you owe them a bunch of money, but you still have control of the LLC. You still have ownership of the LLC. So you can close that door and lock the door and throw away the key. And now no money is flowing out of that LLC, and therefore no money is going to your creditor, which is a key thing. And the reason.
So one question about that before you move on. What if you take a salary out of the LLC? Can you do that?
Yeah. So there's other creative ways, because obviously you can't take a distribution either. And so there's other creative ways for you to extract that. You can take a loan against the company, right? You can take a salary. You can have a management company that you create and become the manager, and get the manager, have a manager fee. So there are other ways, creative ways that you can extract, which is why nobody who's suing you, certainly not plaintiff's lawyers, let's talk about that for a second. Plaintiff's lawyers, the last thing they want is charging orders. They want to foreclose, to your point, like in California. They want to be able to say, Judge, forget this charging order nonsense. I don't want that. I want you to order Jason to hand over his shares in the LLC. So now I own them and I can do whatever I want with them, which is going to be really to liquidate whatever the assets are in and get paid. And so in states like California, this is why California, why Georgia, why some of these other states are terrible, because the charging order is not the exclusive remedy that's available. That's one of many. Other remedies include foreclosure or just flat out a turnover. I don't even have to foreclose. I can just go to the judge, say, Judge, just give me his shares because he owes me a bunch of money. So I want half of the company or all of the company. And they just hand it over. So you want to be in a state where charging order is the exclusive remedy. That's why that's the important language. Is the charging order protection the exclusive remedy available for a creditor that's coming after you? And if the answer is yes, that's a good state to be in. And about half of the states, by the way, have that charging order as the exclusive remedy. The reason why Nevada, Wyoming, Delaware, and now Texas are really even next level is because they're the only states where charging order protection, the exclusivity of charging order protection, extends to single member LLCs.
Right.
So if you have an LLC and it's just you, or you and your spouse, by the way, you and your spouse is generally considered one, then in most other states, they don't use the charging order protection is meant there to protect your partner. So if you don't have a partner, then it doesn't really make any sense. But those states have run, those lawmakers have gone and amended their laws, amended their statutes to include and say, look, if you're a single member LLC, Jason, if you're the only owner here, you are going to have the same protection, the same charging order protection as a multi-member LLC.
Yeah. So to be fair then to California and the other bad states, right? To be fair, if you have multiple members, then you have that same protection.
You don't know, because in California, a charging order is not the exclusive remedy available. So the judge has the right. It says they may get a charging order, but they can also foreclose. It's up to the judge.
Yeah, but not if you have a partner. They can't foreclose on your partner's assets, right?
No, they don't. But what they'll do is, just imagine you and I are business partners, right? Jason, you got into a car accident, nothing to do with our business. There's a bazillion-dollar judgment. The judge gives 50% of the company to you, to the creditor. Now I'm stuck with a freaking creditor as my partner. I want to run the business. I want to grow the business. And now I'm stuck with some guy or gal who all they want to do is liquidate and make my life miserable and just get out of there. That's why the charging order exists. It's not really for your protection, honestly. It's for the protection of your partner, who it's just not a good public policy to put a real business person and a creditor to now run the business. And imagine if you had a majority.
Well, that's why I thought even in the negative, undesirable states, I thought they did give you that same protection as long as you had a multiple member scenario.
One of the protections. It's one of the remedies available. And again, California, the judge may say, look, the way this is going to set up, I'm I'm going to give you a charging order because there's multiple and it's going to hurt the other party. But it's not the exclusive remedy. You're looking for that language in the statute that says whether the charging order is the exclusive remedy or is the charging order, the judge may give a charging order.
Right.
So that's an important distinction. And like I said, about half of the states have exclusivity.
Okay.
But only those 4 have exclusivity for single members as well. And like most of us at some level, even if you run a huge business, at some level, your holding company, your ultimate, top of the chart, it's just going to be most likely you or your living trust or you and your spouse. It's going to own your personal sort of holding company. And so it's very important to have those charging order protections.
Okay.
But again,
so you wanted to make the distinction between a corporation and an LLC.
Yes, let's do that because corporations do not have charging order protection. So if you own a corporation, there is no charging order. They'll just hand over the shares. I can go to the judge and say, hey, Jason owns 10,000 shares of this company. He owes me $1 million. Judge, please hand those shares to me. There is no charging order protection on corporations except for the state of Nevada. The state of Nevada is the only state of the union that does extend charging order protections to shares in a corporation. Everybody else you do not have, which is why LLCs are generally considered a superior asset protection entity over corporations. Corporations are more to run your businesses and have shareholders and all that kind of stuff. But from an asset protection standpoint, corporations are terrible, which is one of the reasons I don't like S corps. For example, if somebody wants to set up an S corp, I talk about that in one of my legal strategies to avoid. And I've talked to all the CPAs as well. S corps, first of all, they don't even exist. They're just corporations that have elected to do an S election to do the pass through. You can do that with an LLC. You can have an LLC and have it taxed as an S corp, and that's a much preferable because you get that LLC structure, which gives you that protection.
Yeah. So I think, though, you need to distinguish here, Mauricio, between the internal and the external threat.
Yes.
So in that example of the corporation that does not enjoy charging order protection, that scenario you outlined is only for a situation where the threat was external.
Correct.
If the corporation itself has a judgment against it,
100%. Yes, that has limited liability. Yes.
Right?
So yes, I should have. I love the fact you did
even
that
on a single member or a single shareholder.
Yeah. So there's, like you said, there's 2 angles to it. There's the inside attack, outside attack. I like to sometimes say you want to protect you from your assets and also your assets from you, because people always think of it as just, hey, how do I protect myself if somebody attacks my asset? And I'm like, wait a minute, you're probably more of a liability producing machine than all of your assets combined. You're out there doing business every day. You're driving your car. You're doing all that stuff. So what happens if you get sued? Regardless of your assets. And that's where the outside attack comes in. So anytime you hear the word charging order, I want you to remember it only applies to outside attacks. That's when you say charging order, we're talking about outside attacks. When we're talking about inside attacks, I like to use more the word like it's the limitation of liability really is what we're looking at, because your liability is limited to what's inside the corporation or inside the LLC. But yes, if you own a business in a corporation and the corporation gets sued, the corporation is a separate entity from you. And unless there's some mechanism to pierce that corporate veil, they should not be able to get to you personally, because you're acting as a separate company, a separate entity.
Okay, very interesting. All right, what do you want to do next? You want to talk about trust?
Yeah, I mean, at some point, the LLC, the challenge with the LLC is that there is still an ultimate owner. So you have this concern. There's a couple of concerns with LLCs. The holes of an LLC is that a judge can always try and, everybody tries to pierce that corporate veil. So again, you have a home, something happens in the home, so the LLC is responsible, but I want to get to the owner. There are mechanisms where I can try and convince a judge to kind of ignore that protection and what's called pierce the corporate veil. And especially if you're a single member, it's not the hardest thing to do, because people sometimes just don't treat them as separate companies. They start commingling their accounts. They don't respect the corporate formalities. They just kind of treat it all as one. And if you start doing that, it gets easier and easier for somebody to pierce that corporate veil and get to you. So that's one concern. And then of course the other concern is again, if you're in California, for example, and you're in a really bad and you have really liberal judges, even though you may have a Nevada entity or a Wyoming entity, it's not beyond the judge to say, you know what, I know that your LLC is in Wyoming, but I'm going to apply California law anyway, and I'm going to go hand over these shares, which has happened before. So there are limitations to LLCs. And so the next layer of that is really to remove you completely from that ownership. And that's where trusts come into play. And when I say trust, I specifically mean irrevocable trusts, which are what we call asset protection trust. Well, I'm not talking about your living trust. One of the biggest mistakes people make, the biggest misconception, is that your living trust has some sort of asset protection value. It does not. Your living trust provides zero, zilch, nada, zero asset protection. Living trusts are for estate planning purposes. It avoids probate, other things.
I think everybody gets that.
Yeah, but you'll be surprised. But an asset protection,
my listeners get it.
An asset protection trust literally removes the ownership so that the LLC, so think about the structure. You have a property that's owned by an LLC. The LLC is owned by a trust. nobody owns a trust. There is no owner of a trust. You only have beneficiaries of a trust and trustees of a trust. So it eliminates that problem of piercing the corporate veil, and you literally do not own that asset. The ownership has been completely removed from the chain of title. And because we live in a jurisdiction where everything is based on chain of title, that's the benefit of a trust. Now, it does have some holes in it because, the judges still have to have control over you, right? So if somebody's trying to sue you and the judge really wants to get to your assets, they may not have control over the asset. They may not have control over the trust, but they have control over you. And they can demand and say, look, if you don't transfer this out of this thing, or don't do this, or don't do that, we can hold you in contempt of court and throw you into jail. And some of the most famous cases around asset protection trusts involve those scenarios where the judge said, hey, hand this over. They refused, or said they tried to, and they ended up spending a year in jail before convincing the judge.
By the way, I just want to make a point about this, because there's this mistaken theory people operate under. And that theory is judges have to follow the law. And in theory, they do. But they can always pull this contempt thing out of their back pocket and do whatever the they want.
Yep.
It's really scary. And they don't even have to follow the law either, because we've all heard about and read about activist judges and so forth that just make these nutso crazy rulings, right? Literally, you can show them the case law, you can show them the statutes, you can show them everything. And one of the things that has really surprised me about the legal system is that judges don't even read the documents. Right. Sometimes they delegate it to their clerk.
Oh, 100%.
Who's a kid. Like, they're a kid, okay? It's some kid in their early 20s.
Right out of law school.
Or maybe going to law school. I don't know.
Maybe even clerking during law. Yeah, they're clerks.
And it's totally shocking. Who knows if they're even reading anything? So they'll rule on things without reading it. They'll disobey the law, and they'll use contempt as a way to just legislate.
Bypass. Bypass. Yeah.
Because
one of the theories, obviously at some point when you create a trust, you end up transferring your assets from wherever it is now and putting them inside the trust, as you know. And so there's always the argument, well, that was a fraudulent transfer. The only reason you did that was to avoid creditors. And so if a judge wants to go down that route, they can say, Jason, I want you to transfer that outside of I can't control the trust, or I can't transfer that asset back into the LLC or back to where I can now have control. And if you say I can't, or I don't want to, or whatever, to your point, they can hold you in contempt of court and can throw you in jail to comply. Now, at some point, when you spend too much time in jail, there becomes a point where, okay, he must be telling the truth, because nobody wants to spend a year in jail. So he must be, and then they let him out. But the famous cases
that'll ruin your life. I mean, you're waiting out the judge, right? Yeah. So,
but here's, one important point.
Jason, basically, folks, I mean, this is welcome to North Korea. That's pretty much what you've got with some of the stuff these judges can do. They're insanely powerful. So it's pretty scary.
And we'll be back with a lot more on this topic with this guest on our next episode.
The following is a blog post found on jasonhartman.com/blog.
Comprehending how economic factors affect the real estate market. The real estate market is a sophisticated system, which is affected by different factors. To name but a few, economic conditions have a decisive role. The demand, supply, and pricing dynamics of the real estate assets are determined by the major economic indicators like the employment rates, GDP growth, inflation, and interest rates. Knowing the line of these economic factors with the real estate market is essential for investors, homeowners, and policymakers alike. Economic factors that determine the tendencies of real estate market. 1. Employment rates and income levels. Housing demand depends on the prevailing employment rates. They are in employment at higher rates, giving them steady income that encourages them to venture into real estate. On the other hand, when there is a recession or high unemployment, people will tend to delay purchasing a home, which in turn will be lower demand and property values. 2. Interest rates. Mortgage rates, as affected by interest rates, determine the affordability of housing. Lower interest rates usually stimulate demand, as borrowing costs diminish, which in turn causes house activity to increase and makes prices higher. In contrast, an increase in interest rates will discourage potential buyers, causing a slowdown in the real estate sector and maybe even depreciation in property. 3. GDP growth. GDP growth is an indicator of the general well-being of the economy. During the times of a strong GDP growth, consumer confidence is usually high, and this results in high consumer spending on housing. Contrastingly, as GDP growth decelerates or turns negative, consumers might prioritize savings over spending, which can have dire consequences for the housing market. 4. Inflation. Inflation reduces the buying power of money gradually. Inflationary pressures can lead to increased cost of construction, and this further pushes up property prices. On the one hand, inflation may have some positive effects on the real estate markets. On the other hand, however, excessive inflation also may lead to economic instability, which can have a negative impact on the real estate market by reducing purchasing power and increasing uncertainty among investors. Case studies: economic factors of influence. 1. The 2008 financial crisis. The 2008 housing market crash and the financial crisis that followed clearly portray the extensive impact that economic factors have on real estate. In connection, the subprime housing loans, absence of regulations, and property prices rise together are leading to a property market crash which is ultimately affecting all the industries. Double-digit foreclosure levels, property value drops, and tightened credit conditions exposed the real estate market's dependence on the economy's state. 2. COVID-19 pandemic. The COVID-19 pandemic led to the increase of unprecedented problems in the world's economy and real estate sector. Lockdown restrictions, joblessness, and economic downturns bring dislocations in housing requests and supply links. On the other hand, the federal fund rate implemented by the central banks weakened the downside effect, giving the ground to an increase in the demand for housing and relating to the urban and rural preferences. Policy recommendations and outlook for the future. 1. While policymakers often turn to measures designed to stimulate and stabilize growth during financial instability, they sometimes fail to do so in accordance with the real estate market. 2. The central bank uses tools like adjusting interest rates to achieve inflation goals and promote economic stability, subsequently mortgage rates and housing affordability as a consequence. 3. Fiscal policies that include tax breaks for housing or infrastructure investments are other instruments for affecting the housing demand and supply through development activities. Conclusion. The interdependence between economic factors and the housing market is elaborate and intricate. The employment rates, interest rates, GDP, or inflation are not only factors of variable which greatly affect the terrains of real estate investment and homeownership interests. Through constant attentiveness to economic variables and evaluation of the impacts of the latter, stakeholders will be able to make quality decisions to manage the adaptive change in the market as well as exploit the possibilities for growth and stability.
Thank you so much for listening. Please be sure to subscribe so that you don't miss any episodes. Be sure to check out the show's specific website and our general website, hartmanmedia.com, for appropriate disclaimers and terms of service. Remember that guest opinions are their own, and if you require specific legal or tax advice or advice in any other specialized area, please consult an appropriate professional. And we also very much appreciate you reviewing the show. Please go to iTunes or Stitcher Radio or whatever platform you're using and write a review for the show. We would very much appreciate that. And be sure to make it official and subscribe so you do not miss any episodes. We look forward to seeing you on the next episode.